Unfortunately, I don't speak Croatian. I'm really sorry, so I have to do this in English. My name is Vincent Robert. I'm a lawyer. I work in Paris, and I'm specialized in intellectual property law. So today I'm going to talk with you about copyright reform, which is upcoming within the European Union. And in particular, I will focus on the challenges that we have to deal with regarding what is called the digital single market. I have 30 minutes to do this presentation, so it will be a really high-level overview of the core point that we noticed about this reform. I will start with some preliminary comments. Sorry. Some preliminary comments regarding what we call the digital single market. Digital single market implies actually two challenges that we have to deal with at the same time. First of all, we have to deal with a digital transformation, a digital revolution. And we also have to go into EU harmonization of our legislations. So I will provide you with some details about these two concepts, which are essential to understand what is going on within the European Union and what may also concern all of us. Digital transformation. Sorry. I'm not digital today. Okay, so digital transformation. There's no proper definition about what is digital transformation. We know that there's a revolution about digitalization coming for years and for decades. And there is no one-step revolution. It was always a constant evolution of our way to use works and our way to create works and our way to broadcast works. And digital revolution covers many aspects of the economy, not only copyright, but also what we call social media, Internet of Things, cloud technologies, e-commerce, big data. I took some examples, 3D printing, but also it's modifying the whole economy because we are facing new models like the sharing economy systems. And this is a very big challenge for lawyers and for rights owners to deal with because every lines are blurred today. Okay, digital transformation raises specific concerns for lawyers. The first one is that internet has no borders, whereas all laws are national. So we have to adapt to this fact. And for lawyers, the main difficulties about this is that we have to find a way to understand the applicable laws, the jurisdiction the courts that have jurisdiction over the cases that we have to deal with, and how can we enforce copyright protection in a globalized world. The other challenges that are concerned with digital transformation is that individual devices are now more and more replaced by cloud technologies. We do not buy, we still buy CDs and devices, but we more and more tend to subscribe to offers, and to offers which will be, limited in time. So this changes the whole way we contract, the whole way we think and we draft the agreements between every person involved in the exploitation of works. The appetite of users has also grown. They want everything, we want everything faster, we want more, we want new offers. We are very waiting for evolution of the offers. And also new creative uses have emerged. it's not only the users, but the users can become creators. We have a lot of many works that use pre-existing works like mashups, remix, supercuts, memes, etc. And they are going all over the internet. And we want to be able to use these works, but we need to find a proper framework in order to be able to use these works. And at last, intellectual property is very criticized today. It has always been criticized, it's more and more criticized, and we have to face received ideas about intellectual property. And as a lawyer, I see a lot of received ideas about the fact that intellectual property would be dead, intellectual property would not be adapted to new technologies. So these are concerns that we have to understand. We may take some critiques into account, but we also need to clarify some things. And the main question is, with all these issues, how can we adapt to the digital transformation? And we have to find, the authorities have to find ways and directions in order to, for each issue, in order to know if we want new exceptions to adapt. Is adaptation the fact that we just put away some rights? Do we want legal licenses? Because it's complicated to have individual management. How do we choose between collective management and individual management of the rights that are perceived and collected? So these are very important issues that we have to understand and choices that we have to make, that authorities have to make. So digital transformation was the first challenge of what we call the digital single market. The other challenge is, of course, the single market. What is the single market? How are we concerned by the single market? Well, we have 28 national legislation, 28 national case law, and we have a need for an harmonization. But we cannot just take one single title and say it's a European copyright. We cannot do it yet. So there's a constant work of the European authorities on the statutes, the directives, the regulations regarding copyright in order to find common grounds in every country. We also have the case law of the European Court of Justice, which has jurisdiction all over the EU. And every text, every statute, and every case law involved here concern every one of us, every creator, broadcaster, producer, and intermediaries. When we talk about the single market, we talk about 4 freedoms that have been set by the European Union. The first one is the free movement of goods. Then we have the free movement of workers, the right of establishment, the freedom to provide services, and the free movement of capital. So these are 4 pillars set by the European Union, and we have to deal with that. But this principle should never, should always comply with the fundamental principle of EU law. And when we talk about the fundamental principle of EU law, we talk about intellectual property, because it's part of what we call property, and it's protected. The freedom of expression is also protected, so as the public interest. So the project for digital single market, which is a project of the EU Commission, is to make the single market fit for the digital age. So we take 2 challenges at one time, and we try to face it. And it's very difficult, it's very hard. The 3 main pillars of the digital single market program is to allow a better access to online products and services, better conditions for digital networks and services to grow and thrive, and boost the economy, the digital economy. So when we look at these 3 pillars, we understand that they are very important for the economy itself, but we may think that they are more focused on the access to work and not on the protection of the authors and of the creation. So the question is, how can we, with this project, defend the rights of the authors, of the creators, and of the right owners, in order to keep a fair balance between all the interests at stake? So to get the single market fit, the EU Commission has decided to amend many areas of law, not only copyright. Therefore, we could consider the digital single market today as a soup with many laws involved. We have renovation or amendment of consumer law, because it's one of the core aim of the project. Public law, because we have to find infrastructures to allow the broadcast and the distribution. E-commerce, contract law, torts, tax law, etc. And intellectual property is, in fact, one ingredient of the soup. And we need to know what place should be given to intellectual property in all this. And what is the place of copyright in particular in the digital single market? When we talk about copyright in the digital single market, we will always have to face different interests. We try to classify these interests into 4 big areas. There are, of course, the authors and the right owners who defend their interests and their rights. But we also have, as I said before, the public and the users who will always be for what they call a free internet, but they have their own interest also. The online platforms will also try to defend their rights, and the producers. And for every question that we will have to answer, I mean, what is the duration of a right, of an intellectual property? What should be the duration of intellectual property right? What should be the remuneration of the parties involved? How can we enforce a copyright or any right, any IP right? For every question, we will have to find our place in this cursor, in this scheme. So this creates much difficulties for the authorities. And as I said before, in many aspects, or in some aspects, the Commission proposal tends to favorize the public position. So we need to defend the authors and the right owners' position too. So I will see with you 2 points. First of all, I will go with the copyright reform in the European Union. It will be a brief presentation. And unfortunately, I'm afraid I will not be able to go in the second point because I'm already running out of time. So the copyright reform in the European Union. First point, I will try to give you an overview of the shape of this reform and what challenges are involved here. So with respect to the shape of the European reform, the text we have today, the only text, European text that we have and which deals with definition, exceptions, and the core aspect of copyright is the EU Directive of 2001. There have been other texts after the EU Directive of 2001, but this one is the core one. It's the main text applicable. And what's interesting to see is about to happen, is that this copyright directive of 2001 was drafted and voted before most of the services we use today on the internet. When we see Facebook or YouTube, they have all been launched after the copyright directive. And in my opinion, these services just changed the way we use the internet. Back in 2001, we were used to Napster. We had our physical devices. We downloaded files. Today we have streaming offers. We have social media. We have the sharing economy, which is booming. So there was a need for upgrade, and the Commission was aware of that. And the Parliament already pushed the Commission to do that. So maybe there was a need for a update of the 2001 directive. I will not go into much detail with respect to the history of the copyright reform, but please note that since 2001, not much happened. We kept the same global infrastructure within the EU. And in 2015, the European Commission launched a new debate, a new, what they call, comprehensive strategy for the digital single market. So since that date, we have had like 5 or 6 new proposals, new drafts that may change a lot of things into copyright. It's a very ambitious plan on the paper, but we'll see if in practice, it's also the case. There's next to come. It will not only regard copyright, but the Commission intends to modify, to amend the way we deal with the data economy, with the Internet of Things. The tax law will be modified, and the privacy will also be modified. But everything is part of what they call the digital single market. So what's in the draft directive that is currently underway? I will just provide you with basic example of core provisions. The first one is that the Commission wants to create a new sui generis right for publishers of news publications. So it's not extending the scope of copyright, which already exists. It's creating a new right that will last for 20 years and that will be owned by the publishers of news publications. This text, this proposal, followed or was drafted in response to a fear against news aggregators such as Google News. And the publishers of news publications wanted to ensure that they will be involved also in this economy. So they will have the right to authorize or not the online use of their news publications. So this is one of the core elements of this text, create a new right. But the text also provides with some mandatory exceptions. The 2001 directive on copyright provided with a list of exceptions, but which were not mandatory. So the member state had the choice to implement them or not. The Commission understood that they may have to provide with more strict regulations or with more enforceable regulations, so they provided with mandatory exceptions. The first one is what we call the text and data mining exception. This concerns mostly scientific research institutes to allow them to get information into a massive amount of data in order to find things up and to allow the research to come. The second one is an exception with respect to digital teaching, which allows the digital use of works for the purpose of illustration for teaching. So this concerns the schools and universities. And the third one is the preservation of cultural heritage. No cultural institution will be able to make copy of their works once the directive will be enforced, will be implemented into national law. They will be able to make copies of works of their permanent collections in order to save the cultural heritage, in order to ensure that it will not be lost forever. So these are three main mandatory exceptions that have been provided by the text. The other point is, how can we provide the intermediaries with more responsibility, and in particular online platforms? In order to do that, the draft directive provides with an obligation for member states to require efficient systems to identify infringing works for online platforms. So they will ask online platforms to provide with softwares or engines in order to better find infringing works, which is already the case for some major online platforms. But they also push online platforms to conclude with authors and right owners agreements in order to secure the chain of title regarding the works they broadcast. So we see that the intermediaries, which were so far only hosts, are becoming more and more responsible of the content they are broadcasting. The directive also provides with obligations of fair remuneration to authors and performers. They may be entitled to have their contract adjusted if the remuneration is not adapted to the revenues collected by the producer or by the person which exploits the work. And at last, we noticed that the Commission pushes for the creation of bodies to help for negotiation of exploitation of audiovisual works on the internet, because it's sometimes very difficult to find your way into all these contractual difficulties. So these are the main points that we noticed about this project. We don't see any real revolution here. We see some specific amendments on various areas which have not always anything to deal with each other. So it seems to be quite impressive, and it also seems to be a very progressive approach taken by the Commission, a step-by-step approach, maybe because of all the interests that are at stake here, that are concerned here. The question is, were these reforms the ones we were waiting for from the Commission? And this project may raise concerns and debates on certain points. The first one is, okay, we know that we need to adapt copyright and intellectual property law to the digital transformation. But is the extension of mandatory exception a solution for that? I mean, do we need to denaturate in order to adapt ourselves? This is one question that will be asked by many right owners. The other question is, on the other side, is the multiplication of sui generis rights, of new rights, this solution to everything? Because we know that we already have many sui generis rights created, producers, etc. But does it mean that copyright is not adapted anymore? Isn't it an element that may allow to criticize copyright scope? That's a question too. Thirdly, what should really be the place of online providers and intermediaries in this digital economy? The amendments suggested by the Commissions are already taken by most of the biggest online platforms. YouTube has their own software to recognize infringing works. And on the other side, it could be very heavy for single or for little platforms to implement such evolution. The question is, do we think that they should be only hosts and take softwares to identify infringing works? Or do we think that they should also have to respond on the contents published on their website? Another point, another concern is more a national concern. In France, we consider that Commission's proposals are mainly focused on the rights of the users, and it's fair. But it also reveals a question of terminology. We don't use the word copyright in France. We use the word author's rights. And when you study the wording in itself, it's just the opposite. The author's right is how can we define the right of an author. The copyright is how can we define the way we can copy things. So this reveals maybe some differences between the different countries within the European Union, and which will make harmonization more complicated than without, sorry. At last, some economic sectors are based on a national approach of copyright. And I'm thinking about, for example, in France, the cinema industry today is based on a national approach. The financing, the way we redistribute the incomes to allow new productions and little industry to allow them to bloom is based on a national approach. So before maybe breaking down all national copyright borders, we may need to agree on a common European cultural policy and on appropriate economic models. But we are here to also push the authorities to take this into account. And I'll finish with the gaps of the reforms for authors and right owners. We should think about how we can enforce copyright in the digital single market, because we need to make our enforcement policies evolve and adapt to the new technologies. We are, in some points, completely overdated with respect to this issue. The other questions are the ones that were raised by the Commission at the very beginning, but which are not in the text today. The Commission was thinking about a single European copyright title within all the European Union, which can be a very seductive idea, but which also can be dangerous. So we would need some clarification about that. The other point is the need for clarification of other aspects, such as how can we deal with private copy on a European scale? How will we do that? Other points, I will not insist on them, were exceptions that were abandoned, maybe temporarily by the Commission, such as the panorama exception, that may need some clarification too. So there are still many unsolved issues in this respect, and we need to make sure that the interest of the right owners will remain protected. Unfortunately, as I said, I will not be able to go into much detail with respect to another point of my presentation, which did not concern the statutes, but the case law of the European Union. In particular, I had prepared some slides about the hyperlinks and the way the hyperlinks are treated by the courts, but I will be happy to talk about this point with any one of you later today. Thank you again for your attention.